Daytime Chicago is sponsored by Watts Guerra.
An Illinois state order now requires teachers and healthcare employees to either get vaccinated or undergo regular testing for COVID-19. I talked to an attorney, Edward Alrad, to find out if they have any legal recourse in this area.
Generally speaking, employees do not. If they're an at-will employee, which means they can be terminated at any time for any reason or no reason at all. Or similarly, they can resign their employment without any reason or for no good reason at all. And so if they're an at-will employee, no. If they're a union member or state employee, that's a little different, and it generally depends on the terms of their union contract. But for the general employee in the state of Illinois that's at will, they're not going to have much recourse.
All right, so recently a dozen teachers fought this by citing the right of a conscience law as a reason for refusing to get tested or vaccinated. Does that have any merit, and could others start doing the same?
So that's only part of the picture. I think there's 5 things at play here. First, you mentioned the Right of Conscience Act, which at first blush, when you read it, it says it applies to and it protects those who refuse to obtain medical or healthcare treatment. At first blush, when you read that, it sounds like that's the patient. However, when courts look at the applicability of a statute, such as that right of conscience law, they look at the legislative intent. And what they do is they go back to the various versions and edits. They may even review the debates on the legislative floor to see what was intended. And every legal scholar I've talked to and has reviewed this issue agrees that that law was intended to protect medical professionals. For example, therefore doctors are not forced to perform an abortion, say, if it's against their beliefs, or a pharmacist doesn't have to give the morning after pill if it's against their beliefs. And so it wasn't intended as a patient-employee protective law. And so if the courts agree with that analysis, then the employees are out. And then the fourth thing I'd say, later this month, the legislature in Illinois is meeting again. Of course, they could revise that law to explicitly include or exclude those employees, which would clarify the issue, would give you your answer. And we don't know what they're going to do. They may ignore it or they may take it up. So that's a big gray question mark. But all of that might not matter, because the fifth thing is President Biden's administration just recently rolled out a mandate that's about to take effect, at least for employers exceeding 100 employees, and that would require much the similar provisions that the Illinois state order is requiring. And so what we have here is a federal law that overlaps a state law, and anytime we have that, it's called federal preemption, and the federal law wins. And so it would be challenging Biden's law or Biden's requirement, not the state law. For example, if the federal government says you have to have a passport to enter the country, the border states, California, Arizona, Texas, they can't pass a law in the state saying, no, you don't need a passport, you can come on in from Mexico. That's a federal law versus a state law. Federal always wins.
All right, if you have any questions about that state order that impacts teachers, healthcare workers, and other employees, you can contact Edward at the email or phone number that you see there on your screen right now. We'll also have his contact information on our website.